Welcome to EUPrivacyForAll Session37 on GDPR, Article 41, Monitoring of Approved Codes of Conduct. Article 38A, entitled Monitoring of Approved Codes of Conduct, was finally renumbered Article 41. It lays down that the monitoring of compliance with a code of conduct may be carried out by a body which has an appropriate level of expertise in relation to the subject matter of the code and is accredited for this purpose by the competent supervisory authority. This body may be accredited according to 4 criteria. First, it will demonstrate its independence and expertise. Second, establish procedures which allow it to assess the eligibility of controllers and processors and monitor their compliance. Third, they will establish procedures and structures to handle complaints. Finally, they will demonstrate to satisfaction of the competent supervisory authority that its tasks and duties do not result in a conflict of interests. The competent supervisory authority shall submit a draft criteria for accreditation of a body to the European Data Protection Board. This is consistent with the mechanism of consistency laid down in Article 63. Without prejudice to the tasks and powers of the competent supervisory authority, such a body, accredited, may take appropriate action in cases of infringement of the code, including suspension or exclusion of the controller or processor concerned. In such a case, it shall inform the competent supervisory authority of the measures taken. The competent supervisory authority shall revoke the accreditation of a body in cases in which the conditions for accreditation are not or no longer met. Finally, this article shall not apply to processing carried out by public authorities and bodies. In Recital 98, it is made clear that associations or other bodies representing categories of controllers or processors should be encouraged to draw up codes of conduct in order to facilitate the effective application of the GDPR, laying down specific rules in different sectors and stressing some key points regarding micro, small and medium enterprises. In particular, such codes could calibrate the obligations of controllers and processors. Recital 99 lays down that associations and other bodies representing categories of controllers or processors should consult with relevant stakeholders, including data subjects where feasible. The notion of relevant stakeholders remains to be defined. Article 44 stresses the fact that a code of conduct shall contain mechanisms which enable the body, accredited by a supervisory authority, to carry out the mandatory monitoring of compliance. Regarding EDPB tasks, Article 64(1)(c) sets the rule of the criteria for accreditation having to be laid down. In Article 57(1), it is enhanced that each supervisory authority shall, on its territory, encourage the drawing up of codes of conduct and provide an opinion and approve such codes. Finally, infringements regarding the monitoring of codes of conduct are submitted to administrative fines going up to 10 million euros and up to 2% of the total worldwide annual turnover of the preceding financial year regarding the obligations of the monitoring body that would not be met. In Directive 95/46, no provision is provided regarding the existence of a body monitoring compliance with the Code of Conduct. However, the working party was in charge of some of the missions laid down in Article 41. What should accountable data controllers and processors get prepared for? Controllers and processors will have to monitor their own compliance to codes of conduct in a continuous way and on the long run. They will have to include regarding the monitoring of compliance, the fact that an accredited body, associations and other bodies representing categories of controllers or processors will stress EU Commission, the European Data Protection Board, Member States and supervisory authorities' requirements regarding specifically the needs of micro, small and medium-sized enterprises. In order to be accredited, a body will have to demonstrate independence and expertise and establish procedures to monitor compliance to the code, establish also procedures and structures to deal with complaints, and demonstrate that it carries out its tasks and duties without any kind of conflict of interests. Such a body will take appropriate action in cases of infringement regarding the code and its provisions, and the controller or processor concerned might be suspended or excluded from the code. The supervisory authorities will be informed of such actions taken by the body accredited. Bodies in charge of monitoring compliance with the Code of Conduct will have no competence on public authorities and bodies. So the key questions triggered now concern the fact that the concrete interpretation of the criteria to be used to accredit a body will have to be defined, and the efficiency of such a body will have to be framed. Regarding collaboration from supervisory authorities and the European Data Protection Board, it might be interesting to know more, notably regarding the feasibility of having a code of conduct drafted, endorsed, and monitored.